Well, hello and welcome to another ADA compliance Q&A. Jess Segovia here, ADA guru, and happy to make myself available to answer your questions, address important ADA related issues. As you know, my specialty is are the operating requirements of the ADA, and so I help agencies of all types and sizes review their ADA related policies, create them, update them, riders guides and paratransit, ADA compliance review, operational efficiency reviews. I interview staff. I look through your processes and really understand how decisions are made and how work gets done. And then I provide recommendations and can even help with implementation. And so I love to do these little sessions just to answer your questions. There's always ongoing issues. Why is ADA compliance difficult? I don't think I think most people think it's difficult because, oh, we have all these requirements to remember. I think the most difficult part, frankly, is the fact that there are a lot of decisions that need to be made by your agency in interpreting the ADA. So if we were to talk about door-to-door service and paratransit, it is your policies that determine how far to assist someone. Do your drivers go up and down stairs, elevators, into buildings, etc., etc. The ADA, I think, is pretty clear that we need to provide a reasonable level of assistance, but that can be open to interpretation, right? And I come across agencies that are very, very strict and try to do maybe a bare minimum, and others that are go well beyond the minimum requirements of the ADA. And what do we tend to call when we exceed the minimum requirements of the ADA? We call those accommodation. So thank you once again for being here and supporting my work. I try to be helpful and a resource to all of you. And many, many of you on the call here I have worked with, I have answered questions for, you've taken my trainings. Good to see you, Mitchell, my friend from Nebraska. Genevieve, always a pleasure to have you on here. So lots of you on here. Laura, yeah. So thank you so much. Always a pleasure to work with you and be available. So, of course, we have lots of different topics we can talk about, right? Non-discrimination. That is the point of the ADA. We do not discriminate against people with disabilities. It is our job to identify barriers and remove them. That is the point of ADA compliance, right? Driver assistance requirements, as I touched on. Of course, our favorite topic, service animals. Direct threat denial of service is an ongoing issue for many agencies. I know I can deny service to people with disabilities, but I'm worried about making the wrong decision. I'm worried about being sued, and I totally understand those concerns, and I can help you walk through that process. We need policies, right? I'm huge on policies. The five pillars of ADA compliance, and policies is number two. Policies are is the guidance that we create so that our drivers know how to do their job, so they can be successful, so they can keep riders safe, etc. So there are lots of purposes, and the role of policies cannot be overstated, right? We need them. And you also know, especially those of you that have taken my trainings, you know that I am a huge fan of if we have a policy, we should be following it. And if we are not following a policy, we should reconsider whether we have it. Maybe it needs to be changed. And I think that includes something like mandatory wheelchair securement. I've been coming across a number of agencies that have good policies, mandatory wheelchair securement as one. But when a rider objects to using the lap and shoulder belt or the seat or the securement system, the agency, maybe the dispatch, the guidance from dispatch is something like, okay, go ahead and let them ride unsecured. Now, that is a choice, right? That is contrary to your policy. So that would be an issue. I'm also an expert witness in lawsuits. And so a lot of my perspective, quite frankly, is to try to help you prepare for the worst case scenario. Worst case scenario is we don't follow policy to secure the wheelchair. There's an incident and someone gets injured or worse. It's in court, and someone like me is looking through your information, and I find that you have a mandatory wheelchair securement policy, yet there appears to be a practice of not enforcing it. I would consider that to be a weakness in your program. Okay, so that's based on my, sheesh, I'm a couple months shy of 27 years in public transit. So maybe that sounds like a long time, but I'm sure there's a handful of you that have been in transit even longer. So. I just came back from Hawaii, my first annual, what I hope will be training in paradise, and we had an amazing time. Here's a picture of part of our group. We had 24 people in attendance. Here's part of that group, and it was really about 2.5 days. I tried to work with everyone, to enjoy the beauty that is Waikiki Beach in Honolulu, Hawaii. And so we went through a refresher of the ADA requirements. We spent a day on the 5 pillars of ADA compliance, helping understand what each role plays within our program. And then day 3 was actually either creating your ADA program. Many agencies don't have one. How do you know if you have an ADA program or not? Or is it just ADA efforts? You don't have an ADA compliance meeting and agenda made up of multiple departments that have ADA compliance responsibilities. Most departments within your agency, yeah, at least 3/4 have some type of ADA compliance requirement or responsibilities. And so, who's managing all of that? And in most cases, I'm sad to say the answer is no one is managing your ADA compliance program. Each of you have your role and you try to make sure you do what you're supposed to do, but there is no overall program. So that was day 3. And people really enjoyed that process of identifying weaknesses. They completed a survey in advance about their services and program, and then I helped them walk through the process of identifying where there were weaknesses, noting where there's opportunity to improve, and then identifying the top 5 efforts once returning back to their agency that they will work on. And it includes things like, what kind of support do we need? How much involvement is there in the approval process? Do we need public involvement? Are resources needing funding? Is some training needed? What type of training might be needed or information needed for drivers if this is a policy that affects your drivers and bus operators? And so this is how we build that plan with you and for you. So couple other pictures. The picture on the right is the group from Hawaii that attended. So we had representation from Honolulu and from the big island of Hawaii. And then we had a group from Guam and from several people from Alaska and Oklahoma and New York and many from California. And I think one gentleman from Oregon. And so it was well represented across the country and across services as well. So, but a lot of discussion, of course, on ADA paratransit, as you can imagine. Last thing I'll share with you, I will be at a couple conferences coming up in November. I'll be at California Transit Association. I will have a booth, so I would love to see you there. And I will be at National RTAP presenting, and I will have a booth, and that is in December in Austin, Texas. And that would be wonderful, wonderful to see you all there. All right. So why don't we jump right in to our questions, our ADA Q&A, if you will. And it's great to see a large group from Ride Trans. So hope you're all doing well out there. Let's talk about damaged wheelchairs. So I quite often am approached by agencies that want to create or have created a policy that states that if a wheelchair is damaged, that services will be denied automatically. And I just want to remind you that the guidance in the ADA circular and in the ADA regulations with regards to denial of service is that there has to be a seriously disruptive or safety related issue that exists. So we don't deny service to people in anticipation of something unsafe. So just because someone's wheelchair might be missing a wheel or damaged in some way, it doesn't necessarily mean that there is a safety issue. Okay. So I just want you all to be really clear and careful about policies like that. Okay. What are similar policies? Wheelchair is missing a wheel. Wheelchair does not have footrests. Wheelchair does not have armrests, etc. These are things that I understand the concern for safety, but we need to have objective information that a safety issue exists. And if you know that one does exist, the damaged wheelchair, maybe it's missing a wheel, is scraping on the ground. We know it's going to be scraping and damaging our vehicle. Maybe we can work with that, right? We need to perhaps document that, and I hope we have video of that. Otherwise, it's just the word of the driver, and that can be easy to refute if it's just someone's opinion, right? So, filthy wheelchairs. Let's talk about filthy wheelchairs. Again, we need to deny, or we are able to deny service if there is a seriously disruptive or unsafe situation that exists. So, we would need to do a really good job at defining what filthy means, right? If there are bugs on the wheelchair and you see them, if there's feces or urine on the wheelchair, dripping off of the wheelchair, absolutely we have what we need to act on that. We should document the you know what out of it. You know, I'm also huge on documentation of incidences and of observations because, again, we make decisions based on objective information, on facts, on our observations. And so if we see these things, that's great. But if someone pushes a wheelchair out to your driver from a facility and they say, be careful, they have bed bugs or fleas or whatever it might be, and you don't see them, the driver does not see them, I think we would consider that to be subjective information, okay? So I hope that answers that question there. We can act when there are verifiable safety related issues. That's why audio and video are so important. That's why I'm a huge fan, as you know, of the drivers filling out a miscellaneous report at the end of their shift, of dispatch who received the call, making notes about the issue and the guidance they provided. And I've recently developed a sort of a new concept about how drivers, I'm not a fan of drivers deciding when to deny service. The ADA doesn't comment on this per se, but in my work and in lawsuits I've been a part of, I'm not a fan of drivers having the power to deny service. I like and promote an approach where the driver, we make them experts at describing the situation, the incident without exaggeration. And it is our dispatchers that are the experts in using the information provided to them by the driver, bus operator. You know, I use van driver, bus operator, that's my lingo. Uh, and then the dispatcher using the information provided makes the decision to deny or not and to provide that guidance. So I think that is, along with my common sense ADA compliance approach, what we're being asked to do. Is it safe for us to do it? Does policy allow it, or is there any issue with our policy? And if I'm not sure, call in for guidance. I think that works really well now with and describe the situation without exaggeration and to follow the guidance provided by the dispatcher. So I think we have another 5 elements. I'm not going to call those the 5 pillars of accessibility, but I will absolutely call those maybe the 5 pillars of ADA related incidents, something like that. So next question from Laura. Hope you're doing well, Laura. Thanks for being on here. What can you share with us related to the use of fold-up mobility devices? All are eligible for transportation. Are all eligible? Can we require the rider to move to a seat due to the collapsibility, and how best to secure such a device? Well, all right. So we have a definition of a wheelchair, right? 3 or more wheels designed, used, modified by people with mobility disabilities, right? To help them with mobility. So the only folding device or devices that I think fit that definition are folding manual wheelchairs and folding walkers. So if we have those baskets that are folding that many people use, I would not consider those to be a mobility device necessarily, but I think that that is the type of device basket that we often will accommodate and allow people to use. So many agencies, and my recommendation on those is we have a policy that states that nothing can be blocking the aisle or doorways, right? So if it's something that is collapsible or folding, we would need to figure out where it can go safely. And so if the only location is in the wheelchair securement area, all of this is dependent on the type of vehicle you have. So if we can fold it and place it out of the aisle, out of the doorway, in the back of the vehicle, wherever that might be, then I think that's the best case scenario. So yeah, only folding walkers and folding manual wheelchairs, I think would technically be considered mobility devices by definition. But of course, or the vast majority of our agencies do allow those folding carts. People put groceries inside, people put their wash and things like that, their clothes. So we have choices to make. How accommodating do we want to be? Do we have space in our vehicle? Right? To what degree do we want the drivers to provide assistance? I'm a huge fan of drivers providing assistance as long as it's safe for them to do that. So can they safely perhaps fold this device? As far as requiring a rider to move to a seat, I think that it would be reasonable to say, in order for us to accommodate the basket, whatever item you have, uh, we're going to need you to move to this location. I think that would be reasonable if there's no other location on the vehicle to place that device or basket safely. So I think that's reasonable. We want to be respectful. I see you have a basket. Uh, it looks like the only location on the vehicle where we could safely transport that would be for you to sit in this seat. Can I assist you in transferring over to that seat? So always being respectful. I hope that is helpful for you, Laura. Here's a question from Davlin. What a pretty name. Wants to talk about at-home ramps and them being unsafe. So we have ADA requirements for ramps, okay? And so technically we could evaluate ramps in any location where we are providing assistance, especially to and from the door, like in paratransit. We have every right to evaluate these locations to determine whether they are safe and compliant. And so if you come to the conclusion, or whoever evaluates this, if you're in California, we have what are called CASPs, California Accessibility Specialists. They receive a special designation. So you could hire someone like that to do it, or if you have someone within your organization or city who can go out and review locations for ADA compliance. And then if we find that an area is not ADA compliant, or a ramp is not compliant, and that's not just steepness, that's also, is it slippery? Are there handrails? So I would definitely recommend referring to the ADA, the building requirements or facility accessibility requirements of the ADA to identify the requirements for ramps. And then that can be your standard, of course, right? And then, of course, you can always choose to exceed that and to allow your drivers to assist people up and down ramps that do not meet the minimum requirements of the ADA, but there might be safety related issues. I'm not in the business of trying to tell you agencies, you should never do this, you should never do that. My job is to share what the regulations state, but also I feel very strongly we get to decide, and sometimes we decide and agencies take risks. And I'm not a fan of those risks all the time, but there are operational realities. And as long as you are aware of those, we have to make wise choices, right? We don't want to put our drivers in harm's way. So I hope that answers the question there, Davlin. Matthew, we are considering implementing permanent eligibility for clients who have conditions, disabilities that will not improve. Are there any concerns about this concept? Well, I can't speak for the industry as a whole, but I will share my opinion, which is I am not a fan, and I discourage agencies from ever having permanent eligibility in ADA paratransit. I don't know what future technology or medication or medical inventions there's going to be. I just don't know. So even though probably there are disabilities that for the next 100 years will never improve and people will get worse and worse as time goes by, maybe that is the case, but just from my work in paratransit eligibility and understanding the challenges that agencies have in meeting demand, and it continues to grow and grow and grow. I'm not a fan of that. What would I prefer instead? If you identify, a rider that has 2 or 3 consecutive eligibility determinations, so, we're talking every 2 or 3 years, they go through recertification. If you're not seeing any changes, and now you see a pattern that their disability is either staying the same after 2 or 3 recertifications or it's getting worse, then I would change your eligibility approach to simply reconfirm their contact information and if there has been any change in their disability. But maybe we don't put them through the full eligibility process. Okay, so that would be my recommendation, Matthew, for how we would handle people with disabilities that are paratransit eligible and perhaps have pretty significant disabilities that we just don't expect will improve. But I don't know what the future holds, right? I just saw video of a lady that was quadriplegic, had not walked in like 25 years, and some technology company put a suit on her that assisted her in walking. And the next thing you know, she was walking in this suit. It looked futuristic. I don't think it's too far off. So I just don't know what the future holds. That's my 2 cents, Matthew. I hope that is helpful to you. Courtney, refusing to take someone with a broken large rear wheelchair, I imagine. Is it against the ADA or not? How do we determine what is considered unsafe? Yeah, I know. How do we determine whether something is considered unsafe? If the wheelchair is dragging and scraping the floor, if the person's feet are dragging because maybe they're missing a footrest and their feet are bleeding. If a driver has to lift a rider's legs because their footrests are missing, and the driver has to lift the legs as they're bringing the wheelchair in, all of these things are considered unsafe slash unreasonable types of assistance. So we need information like that, right? But if you see someone and they're missing a wheel, but the wheelchair for the most part is still operating the way it's supposed to, I don't know where the evidence is to say it's unsafe, right? So we have to just be really, really careful about that. I hope that answers the question. Kind of an additional question on a previous. What about a flat wheel on a mobility device? I have to ask the same question. Is that flat wheel creating an unsafe situation? Can they still get on and off the vehicle safely, even if it is a little slower? If the wheel is flat, I don't think manual wheelchairs have wheels with air in it, but if there's something wrong with the wheel and the driver cannot push the person in the wheelchair without, perhaps injuring themselves, then I think we have what we need there to consider denying service. And so that is a decision of the agency whether to deny service or not. So we want good information to protect ourselves if we do choose to deny service, right? We need to make sure that whatever evidence we have, 9.5, 9.9 out of 10 people would come to the same conclusion. Safe or unsafe. Okay? Question here. C.M. Wilson. Parent has a child, infant in a stroller, refuses to remove the child from the stroller and gets defensive and almost combative when the driver requests removing the child. How are drivers supposed to handle that? So that is not an ADA issue per se, but I will share my experience in fixed route bus with children in strollers. We had a stroller policy that required that children in strollers be removed from the stroller and the stroller be folded and kept out of the aisle. So now, if the child is disabled, but is in a regular stroller, so not a stroller designed for a child with a disability, my recommendation is that we focus on the child being disabled, not the type of stroller that is being used, okay? So you also have every right to create a policy to allow a child in a stroller, and if the parent doesn't want to remove them, you have every right to create a policy that allows that stroller to be in the securement area, I suppose. I mean, agencies can create any policy they want. Why am I not a fan of that? Because I would not want a non-disabled child in a stroller to deny the boarding and the service to a person with a disability using a wheelchair. That might be difficult to defend if a complaint comes in and we are placing people that are not disabled in the wheelchair securement area and by our policy choice, and we are denying people in wheelchairs, that area was designed for people with disabilities. So I'm not a fan of that practice, but there are choices and options out there. On this one, I'm a fan of the more traditional strollers need to be folded and out of the aisle, and the parent needs to hold the child. So if we're talking about paratransit, depending on your state, here in California, children must be in a car seat. So the parents need to bring their own car seat. That's the typical practice here. Some agencies will provide a car seat. It depends. Is it a car seat? Is it a booster seat? Depends on the age and the size and the weight of the child. It gets complicated. Who secures, who connects the car seat, right? Are you training your drivers to do that? If they do it, are they not responsible if they improperly connect a car seat or booster seat? So these are all of the safety related considerations we need to consider. So, hello, hey, Roletta from my friends at PDRTA in South Carolina. Happy to have you on here. Definitely. Next question. And if anyone has a question they'd like to ask, you can also unmute yourself and just blurt that question out. Go ahead and interrupt me. Next question here from Barbara. Could we deny service to a client who keeps sexually harassing our drivers? Absolutely. Now, you need to very clearly define sexual harassment. You look very pretty today. Have a nice day. Oh, your perfume smells very nice. I don't know if I would consider that to be sexual harassment, but it would need to be sexual, the definition of sexual harassment that 9 out of 10 people would agree, yes, that is sexual harassment. So if they're touching drivers, if they're saying inappropriate things, then, but see here too, we also need to have our conduct, our code of conduct policy that we can follow. Because if we don't have a code of conduct policy that comments on sexual harassment, inappropriate harassment, the use of profanity, etc., how do we really hold someone accountable? Reasonably so, if we don't have a policy to connect to this issue. Do you understand? So that's why I continue to kind of push this issue of policies. So no doubt, extreme harassment in any form warrants denial of service, maybe even permanently. But we need a policy to refer to so it doesn't look like we're just making things up. Does that make sense? And a lot of agencies out there, I'm sorry to say, you come across an issue, you don't have a policy on it, but you want to deny service to someone over it. And maybe even the AD says you can, but you don't have a policy and it hasn't been communicated to the rider, which means you haven't created the standards for using your service and when these services will be taken away. So I think it's very, very important that we do these things, right? Next question. Can you explain what minimum accommodation looks like for a transit operator, such as a wheelchair customer? Well, I don't want to use the term accommodation because we use the term accommodation when we refer to exceeding the minimum requirements of the ADA. So I'm going to say, I think your question is really about what is the minimum requirement from my perspective and based on my understanding and work in the ADA and the requirements for assisting riders with disabilities. The ADA and the circular does a very good job, I think, of providing lots of examples of what is considered to be a reasonable level of assistance by drivers, offering boarding and alighting assistance. That includes pushing manual wheelchairs on and off the lift platform, up and down the ramp and onto the vehicle if it's safe for them to do so, right? That's the more challenging part. Is it safe? I keep coming across agencies that have policies that state that drivers may never touch a rider or their wheelchair. That is not the standard in the ADA. The ADA and the circular, the comments by the FTA and the circular are very clear that we may need to come into contact with riders with disabilities in providing a reasonable level of assistance. So what else is reasonable? Assisting with paying fare, not digging into their purse or bag, but if someone says, "Oh, can you grab my pass and tap it for me?" That's considered reasonable, right? Securing wheelchairs, of course. Using the lap and shoulder belt, attaching the seatbelts is considered reasonable. In fixed route bus, if someone asks us for directions or where is where is this stop or what's this location, we should be providing that guidance and assistance to them. If they ask us to hold the vehicle until we take a seat, until they take a seat, that is considered reasonable. There's even guidance in the ADA that says we are to provide a adequate time for people to board and exit our vehicles, which means providing a little extra time if needed because of their disability. So there are lots of great examples in the ADA and in the circular in particular on what the minimum requirement is for assisting. Let's talk about paratransit and door-to-door service. That's often a very challenging one for agencies. I see many agencies, and I love the language that says that, we can have safety related language that says we will not assist people into facilities. We will not go past the first exterior door of a building. We will not go beyond 30, 40, 50 feet from a vehicle. We must keep our vehicle in eyesight at all times. The vehicle must be parked in a safe location. We will not go into dark, unsafe areas. We will not go into private property where we do not have permission or that the public does not have access. We will not go into a location that requires our vehicle to reverse. There are lots of very standard examples of language for how we provide assistance to people with disabilities. Okay, maybe we won't go into an apartment complex. Maybe we need to require people to come to the public entrance of an apartment complex if there are some safety related issues in that complex. Okay, like I cannot exit safely. I have to back up, reverse. And for depending on the vehicle, we're not a fan of that. Maybe it doesn't matter what the vehicle is. We're not a fan of that. So that would be my guidance, Delisa, on that topic, providing general assistance requirements, right? Assisting people with disabilities. Hope that was helpful. That was a lot of information right there. Question from Amber, do riders have a right to refuse to be secured, and how do you handle that? If your policy is mandatory wheelchair securement, you have every right to require and demand securement. Now, the difficult part is when your dispatcher provides the guidance to the driver, let them know that if they refuse wheelchair securement, that services will be denied. Now the real work starts to come. They're angry. How dare you? I'm disabled. You cannot deny me this service. I'm entitled to this and that, but we have every right to enforce policy. I'm also a fan of having signage up. Wheelchair securement is required. This should be your number one policy if you have it in your policy document, right? And so it should be a process. I'll be securing your wheelchair. Do you have any questions? No, I don't want securement. I understand, but wheelchair securement is mandatory. We have signage here that shows, as you can see, that securement is mandatory. Well, I refuse to have my wheelchair secured. Call dispatch, report the issue without exaggeration, and now dispatch hopefully will say, let the rider know, policy is mandatory securement, and if they will not be secured, then we cannot transport them. I'm also a fan of having this conversation before someone gets on your vehicle. Once someone is on your vehicle, they believe they are receiving service. So maybe before a person in a wheelchair boards, maybe we say, just want to make sure you're aware that wheelchair securement is mandatory on our vehicles. Do you have any questions? And if they're going to disagree, let's get them to disagree outside of the vehicle, not while they are in the wheelchair securement area. Okay, so we need good policy. We need to follow our policy. That's my recommendation. We need to have decals, signage to support the driver so that they don't think the driver is just making up a policy. I think all of these things are in my mind, a best practice for helping the driver deal with these issues. Maybe we have, a little brochure or a handout, right? This is the topic of wheelchair securement on vehicles. And someone doesn't like the policy, but they comply. Here's some information on our policy if you would like. If you have any questions, you can call the number there. Let me ask you, who is which role within your organization is most responsible for educating and training, if you will, your riders? Anyone? Who is that? What is that role? Feel free to unmute yourself, type it
I'm
into
a
chat.
hiring and safety officer.
I would love to agree with you, Laura, but no. Yes, we have on here the first person was Brian. Brian
Yeah.
from New Jersey Transit. It is the driver. The driver is, without them knowing it, training your riders. Every time a rider boards, it is as if they are learning how to use your service for the first time every time. It is your drivers that are reminding them what your policy is. It is the driver that is trying to enforce what riders can and cannot do, will and will not receive. So you're right. I guess if we're talking about training drivers, Laura, you'd be right. It's it's your training staff, etc. But the most education that occurs within public transit is between drivers, van drivers, and bus operators and riders. So yeah, Brian, Miguel in New Jersey, please email me at info@adaguru.co, not .com, info@adaguru.co, and I'll send you out some ADA Guru swag. So yes. So if we understand that, drivers, if we accept that, then maybe there are some efforts we can follow to help drivers become really expert at communication and at de-escalating. I know we train them on these things, but it also for them to consider themselves to be educators. They are our best educators in dealing with our riders, all of our riders, not just riders with disabilities. So good job, Brian. Let's see here. Where are we? Refusing someone with hygiene issues that are offensive to others. So remember the guidance in the ADA is that we can deny service if someone is seriously disruptive. I would say, and in my experience, in most cases, excuse me, bad odor, whatever the type, in the vast majority of cases, is annoying, not unsafe. So when we talk about hygiene issues that are offensive, I think we need to embrace the concept that hygiene issues, odor, etc., need to be creating an unsafe situation. So if someone is standing in a puddle of urine outside your vehicle, we have what we need. Do not let them on board, right? Document it, audio, video, all of that good stuff that we've talked about. But if someone simply has an odor, I have drivers during training come to me all the time and they tell me, oh, I had this rider last week. They smelled so bad. Do I have to pick them up next time? And I said, well, tell me about the trip. Did you deliver the trip successfully? Yes, I opened all the windows, but I didn't like it. And I said, well, you answered your own question. You were able to safely deliver the service. Therefore, it does not meet the standard of creating an unsafe situation on board. That is what we need to use when we are talking ourselves through whether to deny service based on odor or hygiene. If you see feces on a wheelchair, that is unsafe. You have what you need to deny service. I also know of agencies that tell me if I deny service to this person, they're going to be stuck in 115-degree heat for the next 3 hours. They bored them. These are the choices, the very, very difficult choices that transit agencies make. Would I recommend an agency to do that? I wouldn't recommend it. Do I understand when an agency does make that type of accommodation? I do, right? It's examples like that, which is why I don't just like to tell agencies, you should never do this. You should always do this. There are these choices. I just trying to help you know the regs say this. Here's our standard on average in our industry. Um, Here are the concerns if you were to make these decisions, like transporting someone and urine is dripping all over the floor. These are the safety related concerns, but ultimately those decisions are yours to make, right? These are your riders and your environment. You know them, you care about them. So that's my perspective, as you know. Another question from Delisa. No brakes or the rubber is missing on the wheels. Just because rubber is missing on the wheels doesn't necessarily mean it's damaging the bus. In most cases, in my experience, the answer has been no. I've actually used wheelchairs missing wheels, right? It's just like the rim in wheelchair securement training. And at least that wheelchair, I can't speak to all of them, did not damage the vehicle. So we do what we got to do, right? Few more minutes, so I'll try to get to as many of these as I can. What are your thoughts on a passenger having a PCA who has cognitive disabilities themselves and have difficulties assisting the passenger? Listen, I do take a hard stance on PCAs in that if someone says they need a PCA and if someone says that person is my PCA, that's all I need and I move on. And now I focus on safety. Is there a safety issue because of this PCA? Usually the answer is no. And the ADA is also, or the FTA circular is very clear. People with disabilities assist each other all the time. So if it's one person using a wheelchair assisting another person in a wheelchair, a person with a cognitive disability acting as a PCA, there is no requirement to say that we need to know in what way is your PCA providing assistance. There is no guidance there, so I have to just say my opinion on that is to just let it go. And if they say this person is their assistant, then just let it go and roll with it. And there's really only something to do if there is a safety related issue. And let's not forget, PCAs do not need to provide assistance on our vehicles or in transit at all. They could assist at home. They could assist at work, right? A person with a cognitive disability who is physically able could be assisting a person who has mobility issues or physical disabilities. A person with a cognitive disability could help carry my bags. So we just don't want to overdo it. So I hope that answers your question there, Charisse. Pretty name. Eric, how should we handle when a PCA gets involved in the wheelchair securement and tries to do it themselves or adjust the tie downs? Very interesting. I haven't found any guidance in the ADA or in the circular on this, but my 2 cents. Who is the only person on any vehicle trained to use the wheelchair securement equipment? Our van drivers and our bus operators. So I also would take a hard stance on this. If I was creating a policy or making a recommendation to an agency that only the driver can secure the wheelchair. Okay. Now, if the PCA has a preference where they would like the hooks to be, maybe the driver can say, okay, fine, that's not a problem. I also agree that that is a good location to secure to, or I'm sorry, that is not a safe location, like to secure to the removable armrest or putting a hook on the wheel or on the footrest, right? We do in training work to avoid those locations. So, maybe if they have a preference, but ultimately the driver gets to decide based on our training where to secure to. Could we provide an accommodation? I suppose we could, but what's going to happen if that PCA gets injured and breaks their finger? I've seen this happen. And now they're going to sue us because we let them secure a wheelchair knowing they did not have any training on how to do it. So that's my stance on that, Eric. I hope that's helpful. Saulo, what a nice name. Saulo, what is the allotted time to reply, resolve to an ADA complaint? Oh, good question. And it's like a lot of the other guidance we have within a reasonable time. I'm pretty sure nothing's coming to my mind on a hard deadline. It's not like paratransit where you have 21 days, right, to provide a determination. It's within a reasonable time. So I think that we would what's reasonable? Maybe I would say no more than 7 days. Maybe no more than 10 days. I would not ever exceed 10 days. maybe maybe 7 days would be the max. I know a lot of agencies, and if any of you would like to type in, what's your response for the number of days to respond to an ADA related complaint? A lot of you are going to say 3 days, 5 days, 7 days is my guess. So, Saulo, there just is no fixed time. I would not exceed 7 days, though. That's my opinion. The answer is really we need to do it within a reasonable time frame. Okay? Maybe 10, the absolute max. And maybe only 10 if we're a really large urban operator and we get a lot of complaints. Maybe then. If I'm a small agency and I get a handful of complaints a month, I don't think it really should exceed 7 days. That's my opinion. Let's be honest, the longer we go, the longer it takes for you or your staff to pull their audio and video, the less likely that audio and video is going to be there and it's going to be overridden, right? So even if you have a 7 or 10 day policy, my recommendation would be to have a practice where you pull the audio and video for all ADA related complaints within 24 hours, within 2 or 3 days max, because it's going to be overridden. So that's in my experience with the systems that I've used. All right. Let's see. Let's see. Can you email me any information concerning ADA? I would go to the ADA circular, type in ADA circular 2016 and maybe public transportation, something like that. And the ADA circular, actually, I can pull the circular up for you really, really quickly, and I will drop it into the chat. So now it's in the chat. So that's for you, Delisa. All right. Yeah. Hope that's helpful for you. That's the best place I would start to learn about the ADA requirements, the operating requirements of the ADA in particular. Let's see here. Where am I? Our triennial review had a few audits asked us to define what reasonable is on our website. Ooh. Yeah. I think we define reasonable by what our policies state, right? It's going to be different. There are so many different, like, what is our reasonable level of assistance for assisting people with disabilities? And all the stuff that I said, what is reasonable? Assisting on and off the vehicle, pushing a wheelchair, using the lifts and ramps and the mechanisms, securement, lap and shoulder belt, right? These are all the ways that we define a reasonable level of assistance by our drivers as dot, 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 dot. So that's how I would go about doing that, okay? Formal policy is 60 days, but going through customer service is 8 days. Oh, do you mean? I hope you don't mean in responding to an ADA complaint there, Erica. Formal policy is 60 days. That's way too long.
Not to respond, what it is that like if you were to send a complaint to DOJ or
Ah,
FTA, their formal policy, I think,
yes.
is about 60 days, but in-house, customer service creates a customer service number, and then you investigate it within 8 days and you respond within 8 days.
Yes, absolutely. Anything coming from the FTA is going to be very comprehensive, and they give you 60 days, and we need to provide a response. Then they need to review the response, and then they need to come to a conclusion. So yes, I think the question here, or my response to the question had to do with ADA related complaints received directly to your agency through customer service, etc. Yes. Um, so thank you, Erica, for sharing that. Yeah, lots more time given. I mean, if you receive anything from the DOJ, you should be very, very concerned. And the first thing that I would do if I were you is schedule a Zoom with me for us to talk about what your issues are and if I might be able to help you. I have a number of clients that are under DOJ purview and I've helped others in the past dig themselves out from under. Whenever DOJ gets involved, you have a documented pattern of issues, and it is not a good thing. It is in most cases only the beginning. So please, if DOJ has reached out to you, email me, info@adaguru.co. Last question. Suspending service to a paratransit rider for assaulting a driver or other passengers. Is that okay? Listen, that should fall under your general code of conduct, whether it's a person or not. right? Physical violence is not acceptable in any form. And so, um, if it's been documented, there's audio and video of it, etc. I think we have what we need to show that this person should be removed from service. And if it was their disability that caused this violent act, then public transit are not the services for them, given their disability. They need some other specialized type of transportation service. And so, whoo, that was a lot of very important issues we talked about today. Thank you so much for your time and attention. I'm not scheduling any webinars in the next several months, but I am taking requests for in-person trainings, a review of your policies. If you haven't had them reviewed in the last couple of years, it's probably time, right? Please always consider me a resource. Many of you know I respond to your emails. I share my opinion and my thoughts and direct you to where information is to support my opinion. I don't want you to just take it. I will also say, and check this section in the ADA circular and it supports my comment, or, I'll often say my thoughts, right? My thoughts are this, my thoughts are that. So thank you all so much. Always a pleasure. You can go to my website, adaguru.co, and I am scheduling the next ADA training seminar, and it could be Las Vegas, it could be Miami, it could be Puerto Rico. So keep an eye out for all of that. All right. Thank you all. Have a wonderful, wonderful, safe day and rest of your week. Take care.